Welcome to Florida Appeals Journal podcast. I'm Jennifer Carroll, and today we are going to talk just a little bit about expert witnesses and hearsay. Uh, we talked in one of our prior podcasts about the hearsay rule and what to look out for. This is a unique topic. When you're dealing with expert witnesses, you have some unique rules when it comes to application of hearsay. And today, I just want to talk about a few points that may be helpful to you in your litigation practice. Just some basic principles to keep in mind when you are dealing with expert witnesses, whether on direct or particularly on cross examination. So, first of all, always remember the non hearsay principle. If it's not offered for the truth of the matter asserted, you're not barred by the hearsay rule. You may have some other prescriptions in the evidence code, but at least hearsay won't stand in your way. All right. So when you're dealing with an expert witness, if you want to ask questions, especially on cross, that establishes your opposing side's expert witness's bias, go for it. You would ask, okay, who did you speak to before your testimony? Who have you spoken to about this case? What did they tell you? What did you tell them? Normally, out of court statements, hearsay. Again, if it's not offered for the truth of the matter asserted, and it's really just for impeachment and going to help the trier of fact assess credibility, and it's for bias, then you can get that in under that logic. Remember that also when you're dealing with expert witnesses, and I think as most of you know, the expert witness can rely on hearsay evidence and inadmissible evidence, but there are conditions to that. Just remember, you have to lay the predicate. So if the evidence you seek to delve into is the type of information that is, quote, reasonably relied upon by experts in the field in forming their opinions, once you establish that predicate, then you can go ahead and have your expert testify. This is the basis of my opinion. This is the type of data that experts in my field normally reasonably rely upon in forming opinions. That's critical. Okay. Now, if it's data that your particular or this particular expert is relying upon, or if this is just data that the expert is relying upon in preparation of litigation, the proper predicate is not laid. And just remember, you're going under 90.702 for these propositions. Now, also remember that the expert witness cannot rely exclusively on inadmissible or hearsay evidence. As a basic case, Carratelli, 4th DCA 2002, but there's several like it, 832 Southern 2nd 850, and I would direct your attention to 861 to 63. They can, if that if that's all they're relying upon, and then you're going to go into the expert testimony is not supported by facts. It's insufficient data. It's based on conjecture. It's based on speculation, not based on any recognized methodology. These are some of the bases that you can move to strike the expert testimony. And there are cases like that go under 90.7052, by the way, and then 932 Southern 2nd 459. That's another 4th DCA case. Certain cases, there are certain cases out there that give you a fact pattern where the expert testimony is stricken. It's a very hard thing to do, okay? You can also do voir dire to test the sufficiency of that expert's opinion and the basis for that opinion, or you do it by cross-examination. And really, a lot of courts just prefer you to do it in cross-examination, but you could try to do a voir dire. Some courts will allow it, and others won't. The judge's preference, but I think if you ask for it, you're entitled to it. And again, you can look at 90.705 too. But what typically happens is you can have a lot of very weak expert testimony, and you can challenge the basis for that testimony. But 9.8 times out of 10, the trial judge is going to say to you, I think that goes to the weight of the evidence. So I'll decide that as trier of fact, or I'll let the jury decide that as the trier of fact. So it's you want to, of course, be more careful, of course, when you're dealing with the jury. And judges, if it's a bench trial and they're the trier of fact, they feel, and rightfully so, that they can see through and make the distinctions that they need to make. But just remember that cardinal principle, and you also may want to preserve your right to appeal on certain issues. And you may want to just really point out to the judge that, Judge, by the way, this is a really weak expert, and here's why, and show that. But you have a good, strong cross, and you can really weaken them in the minds of the judge in a bench trial or the jury in a jury trial. Now, another unique principle when you're dealing with expert witnesses and cross-examination, I always find this fascinating. I believe it's 702, 706, I'm sorry, 706. And under that statute, you can cross-examine the opposing expert witness with learned treatises, scholarly articles, and books. Okay, and you can't do that right on direct. I think we all know that, because that would be bolstering, and you cannot bolster your own expert, your own witness, and say, yeah, this treatise supports what I'm saying. You can't do it. And it's really a 90.403, prejudice outweighing probative value. It's in the courts frown on it. It's not good. But when it comes to cross of the opposing side's witness, you can do it, and it's all fair game. So what you want to remember is you'll ask the witness, is the treatise or the author authoritative? Because that opposing expert witness has to recognize that source as authoritative. And if yes, proceed with your questions based on that, and proceed with your cross. If no, they're going to give you a hard time, and they're going to say, no, I don't think that's authoritative. Then you can have the judge, the court on its own, determine the authoritativeness of the author or the article, or you can get the question of authoritativeness decided by another witness. And what you'd want to do is, if the judge isn't going to do it on his or her own, then you want to proffer that article and request the opportunity to establish authoritativeness through other witnesses. So that's how you can preserve potential error for appeal, by exercising that procedure. And generally, the statements in these treatises aren't considered substantive evidence, but they're very good for impeachment and for contradicting and certainly attacking the credibility of an opposing party's expert. And the other thing you want to remember is you want to give notice ahead of time of the treatises and articles that you intend to use to the court and to opposing counsel. Of course, I've just had judges, they do require that, and you're going to do it well enough in advance if you want to use that. Otherwise, the other side can make a big deal about it, and I've seen judges keep it out and won't allow you to do it. So those are just some basic rules to keep in mind, and basic unique principles to keep in mind when you are working with your cross-examination of the opposing side's expert witness, and gives you a little different perspective on the hearsay principles and application in these unique circumstances. So that's our topic today for our podcast. And thank you for taking the time to be with us. And I hope you find this topic helpful. And as usual, let us know if there are any issues that you would like to see addressed in the Florida Appeals Journal. Thank you again. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.